Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you.
My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. I guess it'll be office time. It's not a windshield time. And the reason that I am doing this as a quick update, I wanted to get this done earlier, but I have spent most of my day prepping for a trial I have tomorrow. So, I haven't even colored the beard in a long time. I've gotten some compliments on the way the gray literally covers half of my mustache. I had been very neurotic about it and colored it. But as you can tell, I've stopped doing that because, well, I caught myself one day. I told my wife that I wasn't vain. And then she looked at me and commented on the mustache. And I'm like, well, that wasn't really out of vanity. But yeah, I guess it probably was a little bit. Anyway, the reason we're here right now is to talk about a court case, a federal court case that may well have a very serious impact for medical marijuana companies in Missouri and other places. So we're going to talk about this. A Michigan medical marijuana seller has been sentenced to almost 16 years in prison. 16 years under federal law. Now, we've talked about the difference between state law and federal law a number of times on a number of issues. While medical marijuana is legal in the state of Missouri per our constitutional amendment, and that in Missouri you now have a constitutional right to use medical marijuana, where you don't have a constitutional right to consume alcohol, take Percocet, take OxyContin. You can have prescriptions for those, but you don't have a constitutional right. That creates an interesting dichotomy. You can be perfectly safe under Missouri law. However, you are still in jeopardy under federal law. Now, we're talking about the owners right now. And yes, even patients to a lesser extent, but really, the feds aren't going to concern themselves with little Bobby in a dime bag or an ounce of weed unless there's something else. And we've talked about that with guns. But so here's the deal. This, in Grand Rapids, Michigan, former owner of medical marijuana dispensaries, and this story actually came from, it looks like Michigan Live, mlive.com. Former owner of medical marijuana dispensaries in several Michigan cities was sentenced Tuesday, January 28th, to nearly 16 years in federal prison. Danny Trevino, 47 of Lansing, who had Hydro World dispensaries in Grand Rapids, Flint, Jackson, Lansing, and elsewhere, had avoided state criminal and civil penalties over the years, but he was convicted of multiple federal charges. Now, the judge in the case, District Judge Paul Maloney, said that states have been changing marijuana laws across the country, and certainly that is true. Quote, but federal law has not changed, end quote. Now, Trevino argued that statutory minimum sentence should apply to him, and that was 5 years in prison. However, the judge sentenced him to 15 years and 8 months. That was the low end of the advisory sentencing guidelines. And under federal law, when you have a criminal case, there will be sentencing guidelines. And federal defense attorneys will go to those guidelines very early on and look at what the charges are and what applies, and they will build the defense to try and argue for the lower range of the sentencing guidelines, or if there's a reason that the court should go under them, and they'll prepare full arguments for that. If you can come up with a reason why the court should deviate from the sentencing guidelines and go lower. Courts will do that, but you have to have a good reason for the court to do that. The sentencing guidelines range from 188 to 235 months. This was not a light sentence he was facing. And of course, it upset the pro-marijuana activist and his family members. People were very upset about it, and they still are. And the word is getting out. And the larger medical marijuana community across the country is getting very, very concerned about this. Okay. There have been arguments made that this was a racist case because his being Hispanic, he was charged, but white dispensary owners were not. Or Caucasian, or maybe my calling them white is racist. Hell, I don't know. Apparently I'm multicolored, so. I can't speak to that. I think that is, if you're reaching for racism in a case like this, you've lost all other acceptable arguments. You're reaching for the bottom of the pool, unless you can actually prove a racist prosecution, and I find that difficult to believe. Now, this guy Trevino has operated a dispensary since 2010. He was convicted in August in a jury trial of 10 felony charges, including conspiracy to manufacture, distribute, and possess marijuana, and maintaining a drug-involved premises. He was not allowed to use the state's medical marijuana as a defense to the federal charges. However, the government did say that he acted outside the boundaries of the state medical marijuana law. His defense attorney says that that's horsecocky. His defense attorney says that Trevino had been successful. He was arrested and charged and subject to search warrants under state law, and that he had beat them all. The charges were dropped less than a month later, and those were state charges for delivery or manufacture of marijuana and maintaining a drug house. They were dropped under state law. Prosecutor drops charges when they either can't make the case, or in some cases, and I've seen this, a local prosecutor, state prosecutor, will drop a charge when there is federal involvement and they know federal charges are coming. They won't spend their money on it. They'll let the feds spend theirs. So he fought forfeitures of funds that were seized by the police that were ultimately returned to him by the state courts. Civil asset forfeiture is a tool that the government claims they use against drug dealers in the war on drugs, but really it impacts a lot more people than that, and it's highway robbery by any objective standard, and there's no excuse for it. It should be illegal. His businesses were raided 16 times between 2010 and 2016. He showed proof that his businesses had done more than $3 million, or about $3 million in sales. He followed every law that was required, that he was aware of. Every single sale of medical marijuana at his businesses would have been legal under laws in 33 states and District of Columbia that allow medical or recreational marijuana, according to his attorney. Now, problem is, and this is where, the AUSA, Daniel McGraw, said that Trevino knew he acted illegally under federal law. He called him defiant, unrepentant, and undeterred from committing the current federal crimes. After federal investigators used a search warrant in one of his locations in 2016, Trevino posted on Facebook, "I guess Hydro World is illegal. Lol, okay." The judge was concerned that Trevino's conduct under federal law was a problem. And the judge said that, he recognized that the legal landscape in America has changed quite a bit. However, marijuana is a Schedule I controlled substance. An ironic thing, Congress has eliminated the mandatory prison sentence for crack cocaine, but not for marijuana. And Trevino knew that the feds were investigating him, and he continued in business. So he's been ordered to serve his time in prison, and when he's released, he will have 4 years of supervised release, and he's been required to pay an $11,000 fine. So 15 years, 8 months in federal prison, 4 years supervised release, and an $11,000 fine. This is something that is legal under state laws in Michigan and illegal under federal law. This is not any different from the state of Missouri, where medical marijuana is legal under state law. It is still illegal under federal law. What does this case mean? Does this case signal that the feds are going to start moving towards broader enforcement? I don't know. I don't know we can read that into it. It could be that this guy just pissed off enough prosecutors in the wrong area, and then they handed the case off to the feds and said, we can't get him, take this prick down. Those conversations happen, albeit with slightly different language, but they do happen. So it is a very, very disturbing case that is going to be, it should scare everyone that just got a license in Missouri, especially the people whose name is at the top of those applications. You know, now one of the arguments is that under state law, he wasn't actually allowed to serve as a caregiver in Michigan because he's a previously convicted drug felon. Prior felony convictions include cocaine, marijuana in 1994 and 2002. He was qualified under state law to cultivate up to 12 plants and possess 2.5 ounces of marijuana for his personal use. Instead, he cultivated thousands of plants and sold hundreds of kilograms of marijuana, generating sales of at least $2.9 million, according to the U.S. Attorney's Office for the Western District of Michigan. His storefronts and grow locations were searched. He had ample time, and he would resume operations shortly after each search. Well, why would he resume operations after a search? Because he didn't believe he was doing anything wrong. And under state law, he wasn't. But he faced federal law. It is a horrible, horrible situation, and I hope that it doesn't hit here. But if you are employed in a medical marijuana facility, if you are an owner of a medical marijuana facility, you need to make sure that you have arrangements for your legal defense, just in case you get Trevino'd. I just coined that term. Keep using it. Trevino'd, where a legal medical marijuana business owner is charged under federal law and thrown into hooskow. That's another word we need to bring back. Hooskow. Let's bring that back. Okay, so that is the update that I wanted to give you. I have to get back to work. I have a trial to finish preparing for, but this is a very important, I'll dare say, critical issue that you need to be aware of.